So today I'll be talking about justice denied, Mr. Hopkins' invisible semen. So DNA evidence has to be looked at in context. It can be probative or might not be probative. If you find DNA at a crime scene, it's probative if the suspect was not at the scene. He says he was never there. He can't explain away the DNA, and so the presence of DNA where it's not supposed to be is what suggests guilt. On the other hand, you can have non-probative DNA, and the idea is that the suspect was expected to be there. He was there before. He can easily explain the DNA. DNA persists for days, months, years, centuries, and so the presence of DNA where it wouldn't be surprising does not indicate guilt. So the case I'm focusing on today is the 1979 murder of Janet Walsh, a 23-year-old woman in Monaca, Pennsylvania. She was strangled with a bandana, and she was found in her home, face down in her bed. The only thing she was wearing was a blue nightshirt top, and her hands were tied behind her back with a bathrobe tie. There was other evidence as well, but in this talk, instead of going into all 15 items of evidence and the 5 different suspects and all the details, I'm going to just focus on some of the most probative evidence. She was in the process of divorcing her husband, and she had multiple sexual partners, which complicated some of the DNA analysis, because these were known consensual partners. So at the crime scene, I'm showing you a focus of the body. So if you were to look at the bedroom, you would see a woman wearing face down, bandana around her neck. Her face is in a pillow. There's blood on the pillow. And all she's wearing is a blue nightshirt. That's indicated in the center. There's the blue nightshirt. And so her head's up to the left, her feet are down to the right. I didn't want to show a graphic image. And there's a bathrobe tie that's binding her hands. And the important thing about this photo is that it shows the proximity of the bathrobe tie, which is a bathrobe that was later tested, it's made of cotton, to the blue nightgown, which is also made of cotton. So these are juxtaposed against each other. This was, at the time, viewed as a homicide, not as a sex crime. There was no semen found in looking at the body. An autopsy was done. At the time, and later on, the police suspected 4 people. One was her estranged husband. Another was her boss, with whom she was having a relationship. The police considered a co-worker to be a prime suspect. There was another man who was a friend of hers, who on the night she was murdered had met her at a restaurant and wanted to go dancing with her. They'd spent some time together at 2 or 3 in the morning before she was killed. And he said afterwards that he just kind of wandered off into the hills, the mud that night, never saw her again. He left town shortly afterwards. And strangely, his checkbook was found a block or 2 from her house a few weeks later. So there are lots of potential suspects that the police were looking into. Nothing much really happened with this, and the case went cold. There was an initial DNA analysis done in 2005, looking at the bandana which was used to strangle her, and that was the cause of death at the time. She was asphyxiated and strangled. But in 2010, there was more cold case funding, and there was a young serologist who found 100 DNA spots. And she was pretty convinced that the death was a sex crime by looking at the photos. And over time, she persuaded the police investigators that this must be a sex crime. And so the focus of the investigation moved. She also knew that she had a lot of tools for finding semen, for looking under a microscope, for doing differential extractions and doing DNA testing on semen. So instead of testing all the 100 DNA spots that she found, she focused on what was easy to test, and that was the semen. Now, earlier, some senior analysts who did DNA at the crime lab had cautioned against testing a lot of these materials because they were known consensual partners and they could be misleading. But at her advice, the sperm hunt commenced. She found with an ALS, an alternative light source, 15 regions, and these were processed. They were looked under the microscope. And so now there was DNA evidence of previous lovers. I'll show you what was found. But importantly for this talk and what you're hearing today is DNA was found on the blue nightshirt and on the bathrobe tie, and it was found on the blue nightshirt right near the bathrobe tie. So they're close together. The prosecutor at the time used to be a public defender, and then he was a prosecutor, and he ran for district attorney in Beaver County, and he lost, so I don't think he's a prosecutor anymore. I'm not sure what he's doing. He viewed this, with his theory, as a sexual misadventure. It was clear to him that how can you explain that there was DNA on the nightshirt in the back, and there was DNA on the bathrobe tie around the area of the hands? And so that sort of drove his thinking. This must have been a sexual misadventure. There was a man straddling a woman, sitting on her buttocks as she was on her face. They were engaged in some sort of asphyxiation episode with a bandana. And the concept is that with one hand, he's holding onto the bandana and he's asphyxiating her consensually. And then with his other hand, he's holding onto her. With his third hand, he's ejaculating. And he hits the nightshirt, he hits the robe tie, and this explains the coincidental location of DNA on these two items. And in particular, what he really needed to explain, and he did do this, was how and when the DNA got there. If you've ever testified about DNA in court, you usually volunteer on direct exam or just offer it up before cross that DNA identification cannot tell you how the DNA got there. And it cannot tell you when the DNA got there. So this was very unusual expert testimony that was needed, and it was not provided by the state police because DNA analysts won't say that. You really can't tell how and when the DNA got there. But this scenario, this prosecutor theory, was key to how he was organizing his case and organizing the prosecution. In looking at a lot of DNA, there was a man who was reluctant to have his DNA taken. This was Gregory Scott Hopkins. Back in 1979, he'd come forward and had told the police that he'd been having a relationship, purely sexual, not romantic, with Janet Walsh. And he wasn't considered a suspect at the time or when the investigation opened up again in 2010 as a cold case. But because he wanted to check with a lawyer first about giving his DNA, he became a suspect. He was a local councilman, former lover of Walsh, a successful businessman who stayed in the area after her death. He was also a known philanderer. He was cheating on the fiancée who he cheated on for the previous wife. That was his nature. He had no known motive, and he had what many consider to be a very solid alibi. There was a pig roast the next morning, and he was in bed with his then fiancée with other people around. There were 4 other suspects, but they followed him around a little bit, and they found a cup that he drank from the water cooler in the town hall. They got a cast-off DNA sample, and then they found that his DNA matched the nightshirt and the robe tie in the location in the small of Janet Walsh's back, and also on the flat sheet in 2 spots. So I'm going to, not in any great detail, after the crime lab looked at all the DNA evidence, we were asked by the defense to re-examine all the DNA. And in fact, additional testing was done at the defendant's expense, and the computer with TrueAllele found more in the DNA mixtures. So TrueAllele is a computer program. I won't be talking about it very much, but people have problems in crime labs interpreting DNA mixtures, and TrueAllele separates DNA mixtures and gets much more resolution for determining when people are present or not in terms of match statistics. And so we did that, and we found more than what the crime lab found in some of the items related to a sexual act, which were oral and vaginal swabs, as well as the pillowcase was actually the reference itself. There was a match to the victim, and items that were related more towards death, like the handkerchief that strangled her, or looking for fingernails for a struggle. Each cue is another questioned item. So there are 3 question items for the handkerchief, 2 question items for the fingernails, and there were no matches found. In terms of clothing, there was the nightgown top, the blue nightgown, and that matched, that was Q3, and there was a match to K7, who was Mr. Hopkins. So there was a match to him. And also, with the bathrobe cord, the robe tie, there was also a match to Mr. Hopkins. And they looked at the bathrobe itself, and in looking at multiple stains on it, there was a match to the victim. We also found a new match to an unknown person. Looking at the bed sheets, which you would expect to have DNA from prior sexual relations, there was a fitted sheet and there was a flat sheet. Here's 2 items from the fitted sheet, the 2 cues from the flat sheet. The victim was found on one, and the husband was found on the flat sheet, and there were actually 2 matches to Mr. Hopkins on the flat sheet. So that was, without going into the dozens of tables that were generated, that's a summary of the sort of evidence that was there. And comparison was made to all 4 other suspects as well. The defense attorney is now the Honorable James Ross. This was his last case before he was elected. He started off as a federal prosecutor. He did defense work for a while, and then he was elected to the bench 2 years ago. And Mr. Ross's theory is that Hopkins was not there when Walsh died, that this was old DNA that was left from before, and there's no coincidence that needs to be explained, because basically the DNA is expected. He also noted that there was no semen on the hands of the victim, which led in court defender Ross to comment on what a perfect shot Mr. Hopkins was, that as a pathologist testified, with 5 or 6 rapid ejaculates happening, he only hit these 2 items of cloth and managed to miss the body. He missed the hands that were up in the air. He just missed everything. And then the key point, but we'll go into more detail, is that when there are known prior sexual relations, the DNA is not all that probative, which is why it's generally not used by prosecutors and not testified to by professional DNA experts who work for crime labs or independently. The point is, DNA does not say how or when it was left. That's not what DNA can tell you. And that's more typical expert testimony from a DNA expert. So now we have 2 competing hypotheses. One is the prosecution's hypothesis that Mr. Hopkins is guilty. He was there, he committed the crime. And key, in terms of forensic analysis, is the semen was deposited at the time of the victim's death. The defense hypothesis says, no, Mr. Hopkins did not commit the crime. He wasn't there at that time, and his semen was left before the time of death. And that's what we'll be looking at, is what can the DNA and how it was left, not the match statistics themselves, everybody agreed what was present or not, but how it was left tell us about the time of death, which was the critical issue. There are 2 main facts. The first is this apparent coincidence, which is the proximity of the semen stains. Hopkins' DNA is on the bathrobe tie. It's also on the blue nightshirt at the base of Miss Walsh's back, and it was also found on the flat sheet in 2 spots. So that looks like an amazing coincidence. How would the DNA all happen to be in those locations? And that's what struck the serologist in 2010, and ultimately the prosecutor. But I have to make a note on the flat sheets, and I won't talk about them more. Regardless of which theory, it involves wet DNA that was in that region that transferred to the sheets. And so it's a direct cloth contact either way. The DNA would have transferred, whether it was fresh, wet semen or DNA wetted later on. In terms of trying to assess The timing, it adds no new information because it's consistent with the explanations of both the prosecution and the defense. So it's not probative or helpful here, but also lets us focus on the main apparent coincidence, the robe tie that bound her hands and the nightgown on her back. So that's what we're going to focus on. So the prosecution hypothesis can explain the proximity. The prosecutor's hypothesizing Mr. Hopkins committed the crime. The semen's deposited at the time of her death. And you can definitely explain the proximity of the semen stains by this direct ejaculation by the killer during the strangling. You can explain why it's there. Maybe you can't explain why it isn't elsewhere, but you can definitely explain this evidence. But he goes further to say that there's no other possibility. He says this over and over again in documents, closing arguments. This is the way it happened, and there's nothing else. And as you heard earlier, that can lead to some reasoning problems. So enter some science. There's a science of DNA transfer. Now, DNA transfer can often be used to explain DNA, to confuse DNA, but it's real. It's been in the news recently, and there have been many papers written on it. This is an interesting paper by Orshott's group that did a number of controlled laboratory experiments on how DNA transfers, with both direct transfer of two things or people coming into contact, as well as secondary transfer through an intermediate object or person. And what this paper and other papers showed is that the degree of transfer from one item to another, one that has DNA, the other doesn't have the DNA will transfer from the first person or item to the second person or item. If there's more moisture, the wetter it is, the more transfer there'll be. If there's pressure, if they're pushed together as opposed to lightly touching, like a vigorous handshake as opposed to just touching. If there's friction, if there's rubbing between the surfaces. And also it depends on the material. Absorbent materials like cotton are more conducive to transfer than harder surfaces like plastics. And so one view, which was put forward, is that not that the DNA arrived on this location on the robe tie in the back of the shirt at the same time in 1979, but instead that the DNA was deposited months before during consensual relations by Hopkins on the back of a nightshirt. And then it dried, and that the DNA was there as an old stain. And there are many ways that can happen in terms of semen just collecting as a pool in the small of someone's, at the bottom of a shirt, at the very bottom, near the perineal region. And so if the DNA had been deposited before on the nightshirt, then, as the pathologists all testified at trial, as Janet Walsh was struggling, she was perspiring, her back was moist, the shirt became wet, and this mobilized the old semen stain on her shirt. And then you have a wet shirt moistening the robe tie. There's also urine involved, but I don't know when that would have occurred, but there's moisture from her sweat or from other sources. And then there's pressure and motion, and the pathologist described about 2 minutes of this type of activity. With the pressure, imagine your hands are tied behind your back and you're struggling. There's a lot of pressure between the two cloth surfaces. And then the sperm can move from the shirt to the bathrobe tie. And then that transfer happens during the strangulation, but the sperm wasn't deposited at that time. It was deposited earlier. And the DNA can be detected years later. As we saw in this case, you can always detect DNA decades later. Okay, so this defense explanation takes care of the proximity. It doesn't look like so much of a coincidence. Why this location? Well, it's not that they were deposited at the same time. It's that it was left on one article of clothing. Semen stains can aggregate at the base of a shirt and the back from clothing, and then at a later time, months later, then transfer. And so that explains the proximity by a transfer during the strangling event due to moisture, pressure, and the material, all of which came out at trial from other experts on both sides. There are Other explanations as well. This seemed like the one that actually happened, but when there's a sexual relationship, there are many ways for semen to arrive on different articles of clothing. Okay, so the first fact, which was the striking coincidence from the prosecution involving the proximity of semen stains. Both hypotheses explain the data. If you're into likelihood ratios, which we won't talk about today, a way of saying it is whether in probability or just straightforward reasoning, each hypothesis equally accounts for the data. It completely explains it. You could say, what's the probability of observing this data given a hypothesis? Let's not go there today, but how well does it explain it? The explanations both fully account for the data, and they cancel each other out. And because they cancel, they balance. And the proximity of the DNA, that apparent coincidence, actually isn't probative in a forensic statistic sense. It's a wash. Okay, so that's the first main fact. The second main fact is what wasn't seen, and that's Mr. Hopkins' invisible semen. So what we also know, now move back to 1979. What we know is that when investigators looked at these articles of clothing and looked at the crime scene, they did not see semen stains on the bathrobe tie. They didn't see semen stains on the blue nightshirt. They didn't see the semen stains on either of the two spots that were on the flat sheet. We know the semen was there because DNA analysis in the last 5 years has found semen there, but they weren't seen by the investigators. They were invisible. Now, who checked this? Who looked at 4 different locations and saw nothing, and when their job was to find something that was there? One was the police investigator, who examined these items by the records within hours of the crime. The pathologist handled these items and was looking for this sort of evidence days after the event. The coroner also had his hands on these items days afterwards. And then the criminalist at the Pennsylvania State Police Crime Lab, a week or 2 afterwards, also looked at these items. So essentially, if you think of it, there are 4 different spots where semen should have been deposited as fresh semen. 4 different people looked at it. And therefore, 16 different examination events either failed or Mr. Hopkins' sperm is invisible. Okay, so the prosecution can explain this invisibility. He can either say that all these people were incompetent, and so we have 4 incompetent people working, doing the investigation that he completely relies on in his case. So I don't know that he went that far. Or if he's going to say that Hopkins committed the crime, the semen was deposited at the time of death, nobody saw them. We know they were there, and they weren't reported. People were looking for them. So they were invisible to their examination. They were invisible, so the 4 examiners didn't see them. Either that, or as the defense proposed, Mr. Hopkins shoots invisible semen. That's in the transcripts as well. On the other hand, the chance of invisible semen, I'm going to show you some science in a second, is kind of low. You can say maybe the detection error rate is 1 in 10, maybe it's 1/2, but basically ask yourself, what's the chance that you have invisible semen 4 times? It's very, very low. It's not very likely. So if you're going to do a balance and look at the likelihood of how 2 different explanations explain data, this explanation from the prosecution for 4 independent, invisible semen shots is not very likely. Let's introduce science again. This is a picture of fresh semen on cotton. It dries in 2 to 6 hours. It leaves a crusted stain. It has a noticeable border around the stain. It's visible in ordinary light. It has a stiff, starchy consistency, something that today people wouldn't do, but in 1979, if you look at what people were doing then, they would touch these materials and they would report on a stiff, starchy, whatever the consistency would be. So the forensic testing at that time had a visual and a tactile approach. They didn't have alternative light sources. They didn't have DNA testing. It was a different world where if it were visible, this is what they would have seen with fresh semen. But with faded semen, weeks to months later, with creasing and rubbing, the crust flakes off, even if it's not further disturbed. If it's wet, the material disperses. And then if it's washed, it can be cleaned out. And all these different ways make these rugged sperm cells that can stay to be analyzed through DNA evidence 30 or 40 years later invisible to the eye. So even if you're looking for it, you're not going to see it, you're not going to feel it, because it isn't fresh. It's been left months before. So the defense hypothesis actually explains this invisibility. They proposed that Mr. Hopkins did not commit the crime. The semen was left before the time of the crime, during consensual relations months before, and it's not fresh semen, so there are no fresh stains. It's faded out over the weeks or months by rubbing, wetting, washing, and that's why you don't see it. That's pretty common sense if you've seen semen stains, which many people have. All right, so let's look at the balance, the weighing of the evidence, which is what forensic statistics does with likelihood ratios. How well can the same data be explained under two different hypotheses, one from the prosecution, one from the defense? Here, the defense hypothesis explains the data and has more weight much better than the prosecution hypothesis. It's just consistent with science. There really is no good explanation from the prosecution, and if you read through his closing arguments, he ignores this data completely. So the DNA invisibility supports more the concept of the DNA here is exculpatory evidence. It indicates that it's probably not Mr. Hopkins, or you would have seen fresh semen stains, which you don't see. Regardless, and I'll go into why a little bit, Hopkins was convicted by DNA. There's a certain, regardless of what actually happens, there's a certain standard news story, whether it's Innocence Project or a cold case. And I've been involved in a number of stories where reporters are trying, or who've been following a story, try to get a message out to their colleagues that something interesting happened that didn't actually fit the standard story. It wasn't that DNA exonerated someone. It was that the failure to interpret it 15 years was rectified by Trulio 15 years later. That's the story. And it's hard to get that story out because it's not what the public's expecting. It's not what people read. Here the story is DNA convicts guilty man. All the subtlety is gone. It fits the mold. And so for most of the news, not the more in-depth news, but for most of the news, that's the story. It's convicted by DNA. Of course, many people thought he should have been exonerated by DNA, particularly because of his invisible semen. And there have been books written about this, articles, a lot of newspaper articles, and they tell the standard story. Justice delayed. Finally, this murderer has been convicted after 32 years. It finally happened. You have to ignore some of the evidence, but it makes for a much better selling story than to talk more about what happened in the science. There have been some television programs on this. The one on 48 Hours that aired again recently and came out almost 2 years ago, last year actually, it tells a really interesting story. It's called Janet's Secret. It's online if you want to take a look at the story. It's not a normal 48-hour story. It's not, here's the beautiful young victim, here is the psychotic killer, and after years the person has been found. It actually walks through the evidence, and it keeps taking twists and turns. Every time you come back from a commercial break, there's another suspect, and they tell the story. It could have been Robert McGrail. It could have been Calais. It could have been any of these people. And then towards the end, they talk about the DNA, and they raise as many questions as they try to answer. Peter Van Sant ends on a very enigmatic note. Well, we have all these results, but did they really get the right guy? That's unusual for television, but they were in the courtroom, and they were expecting an acquittal, as were most people who were following the evidence, and they were shocked when there wasn't an acquittal. There's another show that, I don't know if it's out yet or it's just in the works, from the Discovery Network, That's the second one, never a cold case. So this is an interesting story, and the story is often the normal cold case story, but I think 48 Hours, who were closest to the story and had done more interviews and were actually in Beaver County, got it right. As part of what 48 Hours showed, they did some jury interviews afterwards, and what they have on film, as well as in my discussions with the crew that did the interviews, the crew was struck by what seemed to happen. It seemed like the jury started off acquitting him. But the initial poll was that they thought he wasn't guilty. However, Mr. Hopkins was terrible on the witness stand. He was a philanderer. He was disrespectful. He was rude. And what someone on the 48 Hours crew told me was that several people felt he needed to go to jail for something. Even if it wasn't for the murder of Janet Walsh, this guy was a creep, and he should be put away, which may be why he wasn't found guilty of first-degree murder. And so the jury swayed, and ultimately it moved from acquittal to conviction in the end. And this is interesting. They said DNA evidence was very influential in their decision to convict. That's what they said, and you can watch the video segment. Even though people who do DNA for a living and are DNA experts cannot say how DNA was left, they can say when DNA was left. That was the crux of the prosecutor's case and his closing argument. There was no DNA expert for the prosecution about this coincidence. They brought in notable experts who were not DNA people, but they weren't DNA experts for whom nobody would say something like that. And in fact, many people believed, especially everybody I know who is a legal scholar, law professor, or a working crime lab analyst, or anybody who does DNA, that Mr. Hopkins' invisible semen was exculpatory. That's what the DNA experts actually believed, which is why no DNA expert testified for the prosecution. He was sentenced to 8 years in prison on what DNA experts think is pretty much bogus DNA evidence. Should have exonerated him. Human bias has been brought up by many psychologists. It's been mentioned prominently in the National Academy of Sciences report in 2009 and many articles. Even with DNA, DNA mixtures have the same kind of issues as the rest of forensic science. It's not quite the gold standard that people think it is. But in this case, let's just look at some of the sources of human bias. The young serologist had an ascertainment bias. She found, it was 99 initially, but she found about 100 areas that fluoresce that she could have done DNA on. But boy, would it be easier to work up the ones with semen. You can see it under the microscope. You can do DNA testing on it. You know that there are cells there. So if you have the technology, what is ascertainment bias? I mean, ascertainment bias is the concept if you drop your keys at night, look under the lamppost, because that's where the light is. Don't look where you drop the keys, because it's easier to find something if you have a better technology for finding it. And that's definitely what happened with the serology. The DNA that went to the lab, those 15 samples, were all selected for sperm. So they were all selected for evidence of sexual activity in a sexually active young woman who'd had at least 5 known sexual partners. With the investigators, once this theory moved from a non-sexual homicide in 2010 to it involves some sort of sexual act, the rest of the suspects disappeared. They found a match to Mr. Hopkins, and that was their theory. And now they have a confirmation bias of doing whatever they need to prove it. And their sense was they didn't need to do very much. They had DNA. And DNA in court, the letters stand for D is for do, N is for not, and A is for acquit. Right? Do not acquit. We've got DNA. That's what jurors hear, and that's what those jurors said they heard. We heard DNA. Why are we even in this courtroom? What's there to deliberate? The prosecutor was an interesting character. He had sort of the worldview of a defender in the job of a prosecutor. I'll leave that to your imagination. And he was running for district attorney. and he didn't have a single homicide. And this was easy. You had DNA from an unlikable character in a very prominent murder. So he's a pretty competitive person, and there was a sense he wanted to win this case. Now, whether it biased his thinking or not, I don't know, but it might have. If you read some of the transcripts, he's very aggressive in pursuing this in a way that's more keeping with a defender than you might think with a prosecutor. And the jurors definitely had a social bias, a disapproval bias. Mr. Hopkins did not do well on the stand, and he really pissed people off. I mean, they did not like him. And there was a desire to convict. So there are these various biases that entered. I'm going to close by talking about some forensic policy questions that you might want to think about. They tie into the law and, as well as into policies. There's a question of, first, should non-experts be allowed to testify about DNA? Should people who are chemists or pathologists or internists or surgeons, should they be allowed to testify about DNA, particularly if they opine on how DNA was deposited and when it was left there? In a world where no DNA expert will do that. I mean, honestly, in court, I'll volunteer that on cross-examination to the defense before they even get started. Why wait for the question? Of course you don't know. That's the nature of DNA evidence. And actually, the judge agreed with that. The trial judge kept out the report from a pathologist who talked about how and when the DNA was left that supported the prosecution's hypothesis and said, look, it's a great opinion, and this pathologist is very well known and very well respected, but where's the science? I don't see the data. I don't see the argument. I don't see it coming together. That went to the appeals court, where in a split decision, they basically said, you know, if you have a medical degree, you can give your opinion. And that's true for most things, but there's a question for DNA. If you're interested in law and admissibility, that was decided more on a Rule 702 from the Federal Rules of Evidence and from Pennsylvania State Rules of Evidence that has to do with the reliability of evidence. How reliable is it to have an opinion that's not based on scientific data and methods that are reliable, that have been applied to the data in order to reach a reliable conclusion? But the second part, which wasn't argued, there was no motion for, I think is much stronger. And this is the notion of relevance, Rule 403 in both federal and Pennsylvania Rules of Evidence. And that's the balancing that a judge can do in a pretrial motion to keep evidence out. But conceptually, it's a weighing of prejudice versus probativeness. If evidence is too prejudicial, even if it's relevant, judges can keep it out. And the problem is that DNA is really prejudicial. If you're on a jury and you hear there's DNA against the defendant, why are you there? The idea is, well, what if the results aren't probative? What if they're actually exculpatory? They're not incriminating the person. They're DNA, and they're being offered it passionately by a prosecutor who says, this is the guy, and I've got DNA. So that's an interesting question. And actually, I've been involved in cases where judges have kept DNA out on relevance, where the prejudice was so strong and the probativeness was so weak that it would be dangerous to put it in front of a jury, and it shouldn't be there. Anyway, Mr. Hopkins' invisible semen was apparently exculpatory, and it shows that defendants can actually be convicted on bogus DNA evidence if it's presented in the right way. For more information about what we do, we have a website, YouTube channel, and our focus is more on what happens when DNA evidence itself and the match statistics are far less probative than they're supposed to be. In fact, it turns out, though I'm not talking about it today, that the main match statistic used across the country for 15 years and hundreds of thousands of cases actually is not probative at all. It's a random number. It correlates with the number of tests that were done and how much money you wanted to spend on your testing, and doesn't even correlate with identification information. But if you're interested, there's a whole bunch of talks and papers on that on our website if you want to hear about the dangers of mainstream DNA testing when the statistical interpretation of mixtures fail. Thank you very much.